Hi ladies and gentlemen, my name is Germarie Viljoen, associated with the Faculty of Law of the Northwest University in South Africa. One of my academic interests is the incorporation of the concept of public trusteeship into the South African environmental law, and the aim of this video clip is to merely provide a broad understanding thereof. It is well known that this concept of public trusteeship is founded securely in legal philosophy, and it has its roots in the writings of authors or philosophers such as John Locke and Karl Marx. The theory of public trusteeship derives from the idea that the sovereign or state or government has a duty to act as the guardian or the custodian or the trustee of certain natural resources. Public trusteeship therefore embodies the philosophical notion or theory that governments exercise a fiduciary trust duty over natural resources. This philosophical notion is depicted in various national legal systems. These countries include, for example, France, Germany, the United Kingdom, and the United States, of which the latter, that of the US, has been particularly influential. This notion has also been incorporated into the South African law, and the following South African statutes incorporated the concept of public trusteeship. The preamble of the Water Services Act of 1997 confirms the national government's role as custodian of the nation's water resources. Section 3 of the National Water Act of 1998 appointed the national government as public trustee of the nation's water resources. And in terms of Section 2 of the National Environmental Management Act, also of 1998, the environment is held in trust for the people. The Mineral and Petroleum Resources Development Act declared in Section 3 that the state is appointed as custodian of mineral and petroleum resources for the benefit of all South Africans. And the same is to be found in the National Environmental Integrated Coastal Management Act of 2008, that states that the state is the public trustee of coastal property. In light of the aforementioned statutory measures, it is proper to analyze the concept of public trusteeship in South African law generally. When doing so, two aspects are extremely important to keep in mind. In the first instance, it should be noted that except for the National Environmental Management Act of 1998, which is regarded as framework environmental legislation, the other sector-specific acts find very specific application in South African environmental law. Each of the statutorily introduced concepts should therefore be interpreted on the basis of their specific focus and scope of application. The origin, content, meaning, and implications of the South African water law concept of public trusteeship may, for example, then differ from a similar concept in another environmental legal sector, and should therefore be studied in its unique legal sector. In the water law, for example, different opinions have been raised as to the origin of the concept. Some argue that the concept has been transplanted as a virtual copy or a replica from the Anglo-American law, and others understand it as a common law principle. Some even argue that the African customary law, with its focus on the commons, completed its full circle with the introduction of the concept of public trusteeship. It should therefore be emphasized that when the origin and the content and implications of the concept of public trusteeship is studied, it should be done sector-specifically. Secondly, it is important to realize that public trusteeship is more than the embodiment of a philosophical thought. It in fact forms the core or the foundation of legal regulatory frameworks. In this regard, I will use the Water Regulatory Framework as example again. The statutory introduction of the concept of public trusteeship changed the foundation and regulatory practices of the South African water law in its totality. It led to a regime change that is, of course, a research field of its own. With these few introductory words, it is clear that the full meaning and implications of the concept of custodianship or guardianship or public trusteeship in the South African environmental law are yet to be determined. Please search for my research on the internet. Innovative ideas, collaboration, and even criticism are welcome on the different research projects.